Yes, sir.
And while I completely understand everything you just said, the simple fact of the matter is Miss Wallace did not participate in the lawsuit that I did last year in this case simply because she didn't know the lawsuit existed formally. She may have been getting phone calls. You may have been trying to tell her for months that you were trying to get your child support fixed. All of that may be true. In order for me to sign a court order against Miss Wallace, somebody has to physically go out and put papers in her hand to give me, the judge, the court, the right to change your child support. You understand?
We're back with another case study. You have a father here. He has kids with this woman right here. He's been on child support for a while now, but he's been trying to get a modification for at least the last 2 years because the amount that he's paying, according to him, is too high based on his income. So what do you do when that happens? He filed for a modification. He did that back in 2021. It took a while for him to get a court date, but eventually he did towards the end of 2022. He showed up for that modification hearing, but the mother did not show up. The father was able to get the support modified, but there was one problem. The mother came back. She said that she didn't agree with the father getting his payments lowered and told them that she did not come to court because she wasn't served. According to the court record, she was served by a process server. The father also says that she knew about the court date. She just didn't come. What the judge is saying is that none of that matters because if she's got proof somehow that she really wasn't served by the special process server, then the judgment that the judge made at the first modification hearing is indeed invalid and he's going to have to hear the case all over again. Take a second to make sure that you're subscribed to the channel and click the notification bell for all updates. Won't waste any time. Let's go ahead and jump back into it.
Miss Louise Wallace, would you raise your right hand, please? Miss Wallace, do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down. All right, y'all. I'm not going to lie. I've been doing this for 30 years, and this is the first time I've ever seen the Attorney General's office file a lawsuit, throw out one of its own default orders. They have filed a bill of review, which is a sideways attack on an order that I signed several months ago. It is strange for the AG's office to file a sideways attack against its own court order. What they state in this bill of review is that Miss Wallace has provided them proof that she was not personally served on the modification suit. Miss Alexander, you represent the state of Texas?
Yes, Your Honor.
Have you had an opportunity to review the evidence that Miss Wallace has sent to the state regarding this citation?
Yes, I do, Your Honor. This states that she was served at 8:33 a.m. on August 26, 2022. However, Miss Wallace provided information that she clocked in at her employer at 7:57 a.m. and did not leave until 2:08 p.m., then clocked back in at 2:40.
Okay. Well, Mr. Walker, what says you? I mean, it's like I say, I've never seen the state file a lawsuit to overturn their own court order. So it sounds like there's pretty good evidence that the process server on this case did not actually serve Miss Wallace with the lawsuit. So I didn't have the right or the jurisdiction to grant this modification. What do you say about that?
Well, it took, I think I filed for the modification December of 21.
Okay.
I probably didn't. Yes, sir. I'm just trying to get up to the point, and I mean up to the time around that time. I probably got a notice back about it 6 months later, and then I got a review maybe when it was July, maybe.
Okay.
And it didn't even take effect right then and there. When she gave me a review, because I was at Louise's house, I actually was there with my kids when I did the phone hearing. She knew about it. She went to work that day. I was at her house that day of the hearing. I told the lady in her bedroom. And it didn't even take effect for another 3 months. And I was trying to explain to them, like, I'm not working for the same company. The company I was working for, and Louise knew this because she's seen a couple of my chicks do.
Okay.
I wasn't making any money. They was taking everything for child support.
What?
work for a whole week and bringing home $80-something every now and then. Not all the time, but a good bit of the times. And a couple of times I did manage to make some money, sir. But I'm trying to figure out, because I don't live
Mr. Walker.
Child support was eating him up. They took his payments directly from his paycheck, and majority of the time, he was left with nothing, about $80-something. He went showing this to his baby mama, but of course she didn't care. That's not where you fix it. You have to go back to the courts. Showing her your pay stubs won't do anything.
Yes, sir.
I'm going to believe everything that you just said is true. I'm not even going to think about what you just said not being true. Everything you just said is absolutely true. Okay. It doesn't change anything.
Yes, sir.
When you leave it up to a state agency to fix your child support issue, then you are at their mercy as far as how long it takes them to get it done, how long it takes them to serve people, whether or not everybody in the lawsuit is going to cooperate with your efforts. You left it to the AG's office to take care of this problem, so you are at their mercy as far as how long it takes them to finish it. Okay. And while I completely understand everything you just said, the simple fact of the matter is Miss Wallace did not participate in the lawsuit that I did last year in this case, simply because she didn't know the lawsuit existed formally. She may have been getting phone calls. You may have been trying to tell her for months that you were trying to get your child support fixed. All of that may be true. In order for me to sign a court order against Miss Wallace, somebody has to physically go out and put papers in her hand to give me, the judge, the court, the right to change your child support. You understand?
Yes, sir.
And they didn't do that in this case. We thought they did because they filed an affidavit saying they did, but they didn't. Okay. I'm going to grant the bill of review, Miss Alexander. I don't have a choice. It's a service issue. If Miss Wallace was not personally served, then the judgment is invalid. It's not any good. It's not worth the paper it's written on.
Yeah.
But Miss Wallace is served now.
Yes.
You understand that you have now appeared formally in my court, so you are served with this modification suit.
Yes, I was.
When's our reset date, Miss Alexander, so I can hear?
Let's do, what are we on? Let's do April 13th, Judge.
April the 13th?
Yes.
All right. So this is what's going to happen now. Miss Alexander is going to send me an order that grants the bill of review. That's the sideways attack on their order. And then I'll sign that, get it back to them. They'll file it. That will reopen the original modification suit that was filed last year. And we are going to come back here on April the 13th of 2023, which is only a couple weeks away. And we'll try that modification suit at that time. Okay.
Okay.
All right. The AG's office will send you notice of that hearing date, so you know what the Zoom number is. Miss Alexander, how do you intend to send that notice?
It will either be by mail or email. Let me see how we sent it last time, because we did send both of them notice.
I mean, they're both here today, so I know y'all have some method of getting in touch with them to give them the Zoom information. Okay.
We sent it to Miss Wallace by email and Mr. Walker by mail.
Okay. So just watch your mail or watch your email for the Zoom information for that hearing date in April. Okay.
Okay.
Yes, sir.
You're both free to go. Yes. Did you have something else, Mr. Walker?
Yes, sir. Well, I just need to make sure, because I actually received 3 different forms. Like, I was emailed that yesterday was my hearing. I have 2 letters stating today was my hearing, one at 9 o'clock and one at 10 o'clock.
Okay.
I got 3 different. I called.
I'm telling you right now, Mr. Walker, it's April the 13th that you will get one. I don't know why they may have sent you 2 notices for the different times, just because we're kind of going through some minor changes on how we're running our dockets, but it will probably start at 9 o'clock. They'll bring you in and try to negotiate your case, and hearings will start at 10 an hour later.
Yes, sir.
But it will be April the 13th.
Yes, sir.
All right.
Alright, so that's the end right there. They're going to have to come back to court for another modification hearing. The judge went with the evidence the mother submitted to the state, claiming that she was not served by the special process server. Now, it's obvious that she knew about the court date. The father told her about it and was updating her along the way, but she's saying that she wasn't formally notified and didn't receive the papers. You know, this woman right here is playing games. The father is going through the proper channels to reduce his child support, and at the end of the day, she is 100% against his payments being lowered. But here's the thing though, it's not up to her. When they go back to court, the judge will review everything again, and if it's the same as the first modification hearing, the father will get the same result. This time though, she won't be able to say that she didn't know about it because she appeared before the judge and he told her the date to her face, so there's no excuse. Now, do you hear the father say he received different notices with conflicting dates? I believe that's a tactic though, for the father to miss the date. I don't believe it's just an error. If anything, it's intentional. Let's go ahead and get the conversation started. Let me know below what you think about this case. Special thank you to our brother Edmund. I appreciate you, Edmund, for all of your support, as well as Antonio B. Thank you, Antonio, for supporting the channel. Don't forget that you can support this channel as well. Links to Cash App and PayPal are below. Ladies, fellas, want a balanced analysis, want the truth from a woman's perspective? Then you're going to want to subscribe to this channel and don't forget to like and share.